Any mention? May I please, Your Lordship? Your Lordship, I beg to mention item number 12, Your Lordship.
Number?
12, Your Lordship. Lordship, if the matter may come up after 2 weeks.
This is the other side. Is it criminal appeal?
Yes, Your Lordship.
Okay. Criminal appeal. Yes, Mr. Guru.
Yes, ma'am.
When do you want it?
After 2 weeks, Your Lordship.
Still, at the request made on behalf of the pit, on behalf of the applicant, this is matter. Yes.
Much obliged.
My lord, item 10, my lord, inadvertently, my lord, today I forgot to bring the brief, my lord. I'm praying for a week time, my lord.
No objection, Your Lordship.
Also, at the request made on behalf of the petitioner, list after a week.
Deeply obliged.
Authorised, Your Lordship.
May I please, Your Lordship? I beg to mention item number 16. Kindly allow us shorted.
Item number 16.
Yes, my lord.
Yes. He appearing for the petitioner.
Yes, my lord.
No objection, Your Lordship.
When do you want it?
After 2 weeks, my lord.
This also same order. Yes.
Highly obliged, Your Lord.
May I please, Your Lordship? I beg to mention item number 3. My lord, I pray for 2 weeks' time, my lord, because the conducting counsel is not well.
The 2016 matter.
Yes, my lord, I know. But the conducting counsel is not well, my lord.
You're appearing for?
I'm appearing for the petitioner, Your Lordship. My senior is appearing, Your Lordship, but he's only before the division bench.
You are appearing for the petitioner.
I mean for the respondent, Your Lordship, my sincere apologies, Your Lordship.
I'm appearing for GHDC.
This what is the matter about? Nakmaship?
It's
Yes.
about
This is about land.
Nakmaship? Or land acquisition?
land acquisition compensation, Your Lordship.
Yeah. The man. Who is appearing for the petitioner? You're mentioning on behalf of?
HR not, my lord.
Let's see. A request has been made on behalf of Mr. Richard Nath, Counsel for the petitioner to urgent the matter on the ground. On the health ground. The London Council is paying with the respondents have no objection. Very alert, please take the tool, please.
Excuse me, Your Lordship. Your Lordship, she's for the respondent, Your Lordship, not for the petitioner. It's her partner.
No, Mr. Nath is for the petitioner.
Your Lordship, so my sincere apologies for item. Highly obliged.
Yes, Lordship, I beg to mention item number 14 on behalf of Mr. Karwanlang. He's indisposed.
On behalf of Mr.
A.H. Karwanlang. He's indisposed, Lordship.
He's still not well.
He's recovering, Lordship. He
He's
was
at home now.
discharged. He was
He's at-
discharged from the hospital.
He's at home now. Or
He's
in
at home.
Yes.
My lord.
Yes, on the request made on behalf of the state respondents, so this matter after
2 weeks.
2 weeks. Yes.
Highly obliged.
May I please, Your Lordship? Lordship, I'm mentioning item number 6. Lordship, I pray for 2 weeks' time, Lordship.
Six.
You're appearing for?
Respondent 6, Lordship.
Restaurant number 6. Who is restaurant number 6?
Item number 6, in item number 6, Lordship, because item number 5, 6, and 8 are connected, Lordship.
And what about 7? 7 is not connected.
7 not connected. In item number 5, the private respondents that Sir Qureshi is representing the private respondent. Item number 5 and 8. In item number 6, that Sir Hazirika.
8 is independent. It is.
But
Is it not? This is not tagged together with.
Each tag there is an order, Lordship. There was an order, Lordship. Long back there is an order, Lordship.
But then now, right now, the mention is only made on for item number 6. If item number 6 is urgent, can we take up 5 and 8?
5, when Qureshi also, he is on leave, Lordship, with juniors.
But then no mention has been made. Can you-
Yes. Let them turn come, Lordship. Let the matter be called.
Yes. Let this matter be called and we'll just. Yes.
May it please your lordship. Lordship, I beg to make a mention of item number 11, your lordship. Lordship, I pray if this matter may be taken up after 2 weeks, your lordship, as the learned DHI is indisposed, your lordship. It's a joint request, your lordship.
No objection.
No objection, your lordship.
Item 11. Just say. List after 2 weeks. The request made on the respondent.
Oblige, your lordship. From supplementary list, item number 1.
Similar prayer for item 2, Lordship.
Who is there? Wait. Item
Mr.
number
Shula,
2.
he's on legs, Lordship, before the division bench.
Somebody should be there.
As per his instructions.
In any way, my lord, I am praying for the notice, my lord.
Issuance of notice.
Issuance of notice, and in the meantime, my lord, stay the further investigations, my lord.
Then we have to hear him.
My lord.
There is a prayer.
My lord, this is a case, my lord, I have come across. Is one of a classic case of an abuse and the abuse of the position of law and abuse of the use of the police machineries, my lord. Here, my lord, the allegations made in the FIR does not constitute any offence at all, my lord. The FIR is at page 18, annexure 4, my lord. And my lord, this FIR was registered as Sada PS case number 144, 5 of 2024 on 10th of May 2024, my lord, under section 409, 467, 471, 211, 120B and 192 of the MV Act. May I just read the FIR, my lord? With reference to subject, I would like to inform you that Shri Gabriel K. Yangrai filed a false FIR against the members of the inquiry committee at Sada police station on 09/5/2024. In the FIR, Shri Gabriel K. Yangrai alleges that I have the honor. So this is the contents of the FIR, my FIR. Now, my lord, will come to the last paragraph of the same page, my lord. In this regard, it says, in this regard, I being one of the member of the inquiry committee would like to clarify that based on the order of the police headquarters White letter number so and so dated, an inspection and inquiry was conducted at Central Workshop on 19/7/2022 by the said inquiry committee consisting of Shri M.K. Singh IPS IGP LO, Shri Davis Natsal R. Marag IPS DIG, and Srimati Claudia Lingua IPS Commandant 1st Battalion MLP 1st Battalion. The committee submitted a report to the police headquarters on 20th of 07/2022. Shri Gabriel K. Yangrai has quoted para 1 of page 3 of the report in the FIR. However, Shri Yangrai K. has deliberately not mentioned the date of the submission of the report. I would like to inform you that based on the inquiry report which was submitted to police headquarters on 20/07/2022, the police headquarters has registered the said vehicle, that is Varna 1.6 VTVT, on 22/07/2022, and a copy of the registration certificate for the said vehicle was submitted by Shri J. Yangrai himself in the FIR, which clearly mentions the date of the registration of the vehicle as on 22/07/2022. He deliberately ignored the fact that on the date of the inspection inquiry, that is on 19/7, the vehicle was not yet registered but was subsequently registered only on 27. After the inquiry report was submitted on 20/07/2022, was in fact the false registration number plate on Varna 1.6 VTVT till 22/07, generally put under the orders of Shri K. Yangrai, who was then serving as Assistant Inspector of Police. It is apparent that Shri Yangrai has malified intention in harming the members of the inquiry committee, namely MK Singh, IPS, so and so, and therefore he has filed a false FIR with the intent of making false charge of offence made with intent to injure, which is a criminal offence punishable under section 211 of the Indian Penal Code. In view of the above circumstances, I request you to kindly take necessary action. So accordingly, this was registered, my lord. This was registered. Now, on the face of this FIR, my lord, no offence can be said to be made out of section 409, which is criminal breach of trust by public servant, my lord, and also 467, the forgery of valuable security or a will, my lord, or section 471, which talks about using of a genuine, a forged document, and also, my lord, section 211, false charge of offence met with intent to injure, my lord. Now, my FIR, my lord, now before that, my lord, he said one thing, what he said is a false FIR against the members of the thing. No, the basis of my FIR, my lord, against the former DGP, and also requesting to conduct inquiry against the inquiry committee, my lord, is based on both electronic as well as documentary evidences and also information obtained by way of an RTI.
Investigating authority will determine what are the basis and all.
My lord, I'm saying that the FIR that I filed, my lord, that was based on those, my lord. So,
so whether your FIR is false or not, we are not going to determine that in this matter.
It is not going to determine, but what I'm saying is that, my lord, when this is when the allegation of false FIR, when it comes to me on that one, I'm saying that that is based on electronic and as a documentary evidences that I file an FIR. And secondly, my lord, here the complainant says that the committee submitted its report on 20th of July 2022. Now, my lord, we'll just turn to one page, page 22.
Yes.
Page 22, my lord, this is dated 25th August 2022. 25th August 2022. It says to so and so from Assistant Inspector General, subject, handing over of documents in connection with report submitted by inquiry committee. Sir, in inviting a reference to the subject cited above, I am directed to hand over the following files along with a detailed report submitted by the inquiry committee for favor of your perusal and necessary action. Can you look at the date, my lords? It is the 25th of August 2022 when the report of this was submitted, my lord. And also, can you look, my lord, if my lord will see next page, page 23, my lord. Next page, page 23, my lord. This is the Shillong Times. Can you look at the date, my lord, August 23? Even
what for you are referring all those things?
No, what I am referring here is, my lord, even themselves, he is contradicting so much, my lord. He is saying that 20th he has submitted the report on 20th of July, whereas the record says they have submitted on 25th of August. And before 25th of August, the newspaper report has already come.
This factual aspects will
Yes.
be determined by the investigating authority. This court will not go into all those things at this. The basic thing what is required
Yes,
to be projected before the case is
Yes.
that the FIR,
yes,
which is under challenge,
yes.
does not disclose any offence.
My
It is, you see, like even if you say that the ingredients of section 467 or 409 or 471
yes, my lord.
has not been made out, that
Yes.
also cannot be ground for it. Because the alteration of charges can always be.
My lord, in this context, my lord, there's a landmark judgment, Bhajan Lal, Lalita Kumari, my lord, which very clearly says that if
If no cognizable offence is made out.
yes, yes, when
This is what
where the
Bhajanlal-
allegations,
Bhajanlal paragraph 101 or 102. What-
this is
what-
1021, where the allegations made in the first information report on the complaint, even if they are taken on the first value and accepted in the entirety, do not prima facie constitute any offence
Yes,
or make out a
any
case against the
offence.
accused.
Any
The-
offence means not
Yes.
under any particular.
Any offence, my
So
lord.
the allegations made in the FIR,
Yes, my lord.
as you say, may not constitute an offence under 467 or 409 or 471. But then it may constitute offence under some other section of it. So this cannot be a ground for question.
My lord, when, my lord, looking at the contents of this FIR, my lord, kindly look the contents of this FIR, my lord has read it, and kindly look at the intention behind filing of this FIR, my lord. Where is, I asked a question to myself, where is that one?
Merely because a counter FIR is filed, can it be
It is
termed as-
wreak with vengeance, my lord.
The law doesn't stop anyone from filing.
No,
counter-
no, but my lord, when it's prima facie shows it's wreak with vengeance. The question here is, my lord, is one of the member of the inquiry committee, he's saying that I have done my inquiry, I have found this. How dare he file an FIR against me? The language, the posture, the language speaks this, my lord. Yeah. And my lord, when you are saying that,
Because he alleges that you have filed an FIR,
yes.
making false statement.
No, my FIR, my lord.
Now your FIR was
Yes.
ill intention. You filed that FIR with ill intention of victimizing the member of the inquiry.
My lord. Not
Now,
victim.
Mr. Yovin,
Yes,
you
ma'am.
know law very well. You see, the scope is very limited.
My lord.
It may not go into all those small issues to determine who is correct and who is wrong. You leave it to all those things to the investigating.
My lord.
Now, what happened to the filing of the pursuant to the filing of this FIR? What happened?
My lord, the pursuant to filing of this FIR, my lord,
10th May, so at least more than a month.
month in a month, and I never knew this about this FIR until, my lord, they issued me a notice under section 41A and asking me to appear on 19th June, my lord. 19th June. Just
Today is
20th of June, my lord.
Okay, so 19th is
Yesterday,
over.
day before yesterday, my lord.
yes. So what happened?
My lord, I have, because I got leave to go for a medical treatment in Delhi. I have requested the IO to postpone because I was out of since Saturday, my lord.
And it's okay. Then if you have written like this, let us see what happens. At least it is not a stage right now to stay the investigation. Let this matter be investigated. Let your version and this version be placed together. Is it filed before the same authority? Whether the FIR filed by you
My lord,
and FIR filed in this case,
My
this
lord.
one
my lord.
is before one authority.
Yes, before this other police station, my lord.
If it is different authority, then we could have said that there would be overlapping on investigation. We cannot
And,
say there is no
another
overlapping.
aspect also, my lord. There is already FIR 7 FIRs, my lord, emanating from the same report, my lord, and also deals with the vehicle registrations, my lord. Same registration. So this is, so to say, this is the second FIR, my lord.
But then this FIR confines to only to the aspect of filing of false FIR by. Now that is what.
False FIR, that is what I'm saying, my lord. False FIR, it can at least investigate under section 211. Why section 409?
That will be seen. That is why. So we cannot quash. You see, later on that will be there. You know very well that this charge can be altered. Even say supposing if you file one FIR under some particular section of law, and after investigation, the charge sheet may be filed under different section of law.
So, my lord, now, my lord, 409 and 467, these are cognizable offences, my lord. Even if section 41A is what, if
about
I'm not
the
able
others?
to answer,
What about 211 and all?
I'm
Are
sorry.
they cognizable or not?
211 is not a is not, my lord.
Moment you know law very well. Moment it is clubbed together with cognizable and non-cognizable, then it will be considered as a non-cognizable.
My lord,
We'll issue notice,
therefore,
we'll
my
just
lord,
see. That
my
is-
lord, and in the meantime, my lord, no coercive action. At least that protection may be given, my lord.
41 has been issued. You see, like law protects you nowadays.
My lord,
You are not arrested then.
under the same sections, my lord, under the same sections, my lord, the person against whom I file an FIR, my lord, came before my lord, and my lord,
We'll post this matter next week. Let them take instruction.
my lord, my lord has 6 has given an interim protection of no coercive action should be taken against him, against the person against whom I filed, my lord. That is at page 17 or page 15, my lord.
Your FIR was directed against whom?
It was directed against Lajaram Vishnoi, my lord.
What is the order? What is the thing you have?
Page 15, my lord.
What is the punishment? Maximum punishment
In
under
409, my lord, it can extend to 7 years, and in the 467, my lord, it can extend up to 10 years, my lord. These are the most.
this is a different thing. Here your FIR has been filed by somebody else, not by the same person.
No, my lord.
The criminal petition, the order of criminal petition which you are referring to,
Yes,
it was filed by different person. Here the
Young Rai.
yes and
No, FIR was filed by Young Rai, my lord. Against.
okay, but then here in this
Yes.
case,
Yes, the FIR is filed by.
the petitioner in that criminal petition. In criminal petition 31/2012, there it is Lajaram Bisnai.
Yes.
So Lajaram Bisnai is not the author of the FIR which you are challenging now.
No, he is not the author of the FIR, but he is the committee. He is one of the member of the committee against.
Maybe,
yes.
but then it's not Lajaram. We'll issue notice. You do one thing. We'll
No, at least one word, my lord. No coercive action, my lord.
We'll let them take instruction. We'll just see.
My lord, kindly give me the same protection, my lord, against whom I have also filed, my lord. These are, my lord, by now, my lord, have understood what is
See,
happening there, my lord.
41 notice has been issued to you.
41, my lord.
See, so long you comply with that, there is no threat of arrest. That is what the law is.
My lord,
If you violate only, then only the question.
my lord, if I am
You
not
are-
able
you are
to.
not escaping, isn't it?
No, I'm not escaping, my lord. My lord, I have been arrested 7 times, my lord. Emanating from this thing, my lord. I have a fear of getting arrested 8 times, my lord. Kindly appreciate this fact, my lord. 7 times I've been arrested based on this thing, my lord. I was 1 year, my lord. Fallen from
Yes.
glory to nothing.
Petitioner's custody is needed. Here. You take instruction. We'll have it. Tomorrow. Why these are? It doesn't seem to be very serious. You see, it is nothing. You have battle of. You see, like ego maybe. Just one side is fighting one side, the other side is fighting this.
My lord,
This is something you see. One just cannot come to court for each and everything.
my lord, once my lord is.
Now the fact remains that you see, FIR filed by you.
My lord,
Now
when.
this FIR says that what the FIR which you have filed is not correct. You have based your FIR on false information, and then your purpose was basically to victimize this inquiry committee. Now it appears that it relates to the same subject matter, so let it be investigated. What is the problem? FIR counter FIR to be investigated with same authority.
My lord, when there is no offense met out
See,
at all,
right now, if we, since in your case, section 41 notice has been issued,
yes, my
if
lord.
we pass any order, then you will never appear before the investigation.
Section 41 itself is wrong, my lord. When there is no offense at all met out here, I have read entire thing. I've read the ingredients of the
That
sections.
is what you are interpreting.
My lord, entire thing I've shown to my lord, and I'm saying that this is just to wreak vengeance against me, my lord. And how can somebody be taken to allowed to be taken to wreak vengeance by moving the criminal into motions? This I ask a question to myself, my lord.
It is filed with what purpose? Okay, that is to be determined. You see, we cannot go look enter inside anybody to see all those things. Okay,
My lord,
the court goes by whatever is there in the evidence. Okay,
this is what
now
I've
if you
yes.
say that this filing of this FIR was barred by law, could not have been done, then it's a different thing if you can establish it. But then it doesn't appear.
Kindly look at my lord. They're saying that they're saying the report was submitted on 20th. Whereas the report itself on page 22 says that the report was submitted 25th. And Shalong Times comes out on 23rd before the report submits.
So, but then what is by if you accept that, what it will prove then?
No, my lord, because the allegations in the FIR itself is false.
The very allegation that you filed a FIR,
Yes.
you filed an FIR with an intent to take revenge on or to victimize the inquiry committee members, that remains. So you are going to some merit. See, merit will definitely see.
No, my lord.
You are relying on Bhajan Lal. See the proposition of law Bhajan Lal. We cannot make roving inquiry in the matter.
No, my lord.
Enter into merit.
No, my lord, I am not asking my lord to go into roving inquiry. I am just pointing out, my lord. Number one, I said that there is no ingredients of offense met up against me, and purportedly
let them have instruction. We'll have it.
Purportedly, this was done to wreak vengeance, and the contents of the FIR itself is wrong.
We'll have this matter tomorrow.
Tomorrow.
Yes, list is matter tomorrow. In the meanwhile, the London State Council should take instruction. Necessary instruction in the matter.
Obliged. Tomorrow.
Yes, tomorrow. That is because you have a fear of arrest. 41 notice has been issued. I do not know why you have a fear of it. Fear of being arrested. I don't know.
41 itself, when there's no offense have been met out, my lord, at least do some.
I don't think for this kind of cases your custodial interrogation.
My lord, I have every apprehension. 7 times I've been arrested, my lord.
Is not in a mood to disturb.
I have been arrested 7 times for nothing, my lord. I've been arrested 7 times for nothing.
That is what would be determined later whether it is for anything or for nothing. See, we cannot.
I've been arrested, my lord. I've been arrested for actually saving 37 lakhs of the government's money, my lord. That of course that would be in the trial stage, my lord.
That you put it in the trial when you face.
My lord. That is why I fear, my lord. Section 41A is nothing. They will call me. They will investigate me. They'll say that they need my custody. That my answer is not satisfactory.
Nowadays,
this is the fear that I have, my lord.
Nowadays, arrest is not like before. You see, the Supreme Court has basically created a bar for this. The police cannot go and the arrest random without issuing notice under 41. That has been done. That is extra protection.
My lord, that I bow down, my lord.
Decision of that. What is that case?
That is Ernest Kumar's case, my lord. My lord, obliged.
Item number 3. Daily list item number 1.
Yes.
Your Lordship, the petitioner counsel is on sanction.
You are appearing for?
I'm appearing on behalf of Dr. N. Mosika, DSGI, Your Lordship.
Yes. What is the matter about?
Your Lordship, this is a matter about demotion of the petitioner from S5 to S3 category, and then he was discharged from service.
Demotion as a punitive action.
Yes, Your Lordship.
Was it a punitive action?
Uh,
Demotion was taken because of some punishment inflicted on
Your
him.
Lordship, he was tested for alcohol dependency syndrome. So he was demoted from S5 to S3, and then he had been discharged from service.
Oh, that is because of the deterioration of the medical category.
Yes, Your Lordship.
And he was what? S3. He was found to be S3 or S5.
He was first S5 and then demoted again.
S5 will, if he is S5, then he will not be suitable for retention in service.
Your Lordship, they had demoted him first, according to the facts of the case.
What is his medical category? The rules provide for demotion because of low medical category.
Your Lordship, as per Rule 17D of the Assam Rifles Rules of 1988,
Yes.
so it has been stated that persons placed in low medical categories, he was placed in low medical categories, so they will have to appear before the medical boards every 2 years for review or
That is okay. That is
recategorization.
probably this code also knows. But then, where it is provided that he should be demoted, we can understand that if he is extreme low category,
Yes, Your
say
Lordship.
supposing if he comes to S5, then he may not be suitable. He may not be suitable. He may be suitable for retention service. But then,
Your Lordship, there's a provision for recategorization. It's so Your Lordship, it's
decategorization, does it mean demotion?
Your Lordship, when you are recategorized, some relevant.
Recategorization, does it mean demotion? Recategorization would it mean the person can be demoted?
Your Lordship, with that we need some clarifications, but according to the what I have knowledge of,
None
it's-
appears for the petitioner. Write her name, Miss So and so, appears on behalf of the. List this matter after 2 weeks.
Item number 2. Your Lordship, item number 2 is connected to item number 1.
Connected matter. Same order.
Yes, Your Lordship.
Same counsel.
Yes, Your Lordship.
This is also low medical category.
Yes, Your Lordship. Both of them are on alcohol dependency syndrome.
Both are together.
Uh,
Friends.
Your Lordship, no, Your Lordship, they have been tagged together, but
Same order.
much obliged. From supplementary list, item number 4.
My Lord, Mr. Rakhal has just informed me that he has a matter in division bench and requested for at the bottom of the matter, bottom of the case. Bottom of the case, man.
Bottom of the list.
Yes, man. He's requested for
already
that.
have already one matter put into the board. It becomes a problem. Isn't it?
Hopefully he'll come immediately. He said he'll come immediately.
We'll release it from partner. Let it be listed in this. This way you cannot. See, this is a kind of thing. Even the court also doesn't remember what happens. You see, like if there is a gap, their matters are not disposed of then and there.
God has, Lordship has given enough time for this. Even Lordship not convenient today, matter may be considered tomorrow also. He has just informed me that he'll come very soon. Otherwise, we are ready. He has given us the copy.
How do you know that tomorrow also will not have any difficulty? It's a problem again. Anyone appearing for Mr. Devnath?
But he just told me that he is coming very soon.
No, he cannot make any prayers who he use. He has to send somebody, isn't it?
Exactly.
If he is there, at least some of his
He
associates
should be.
there.
He should be.
Just Mr. Ichil Sangesh, senior advocate. Is present along with so and so. On behalf of the petitioner, none appears for the respondent.
Respondent, private respondent. I am for the state respondent.
Mr. Ichkani appears for the
State respondent.
none appears for the private respondent number 527.
Yes.
567.
567.
List matter tomorrow. We'll have try tomorrow.
Right.
We'll just give try tomorrow.
Yes. I'll inform him.
From the main list, item number 4.
Is Mr. Sangre show that item number 5 in the supplementary list is also connected matter?
Yes. 4 and 5 are connected. Similar. Connected.
5 also, you just say Passover for the day. List, keep tomorrow.
Yes.
Okay.
Yes. Give the order.
This is
Meet, please, Your Lordship.
Item number 4, daily list.
Lordship, we are supposed to file a feedback, bring on record, Lordship, but Lordship, senior counsel has some small submission to.
you make the submission. Whatever the small submission, you make this.
Lordship,
We are not adjourning the matter. These things, court cannot function like this.
Lordship, kindly let the
If
matter
counsels
come.
are not there, then matter will proceed. Not possible.
Short pass over, Your Lordship.
No possible.
Lordship,
Yeah, what is that small submission? You just say.
Lordship, I'm on limited instruction.
Otherwise,
Your
we will
Lordship.
hold that petitioner is not interested. We will dismiss for default.
I'm on limited
Nothing can be
instruction,
done.
Your Lordship. Kindly grant for pass short
See,
pass
this
over, Your Lordship.
matter is pending for filing for an application for striking of the name of the petitioner number 1.
Lordship.
For how long? Until it appears that till now you have not filed an application.
Lordship, in the earlier occasion, we are finding difficulties in connecting with the client, but we just made
See,
recently
if
we
the
just
client
made.
is not interested, we can understand that you have this. So once the client is not interested, why should you be interested?
No, actually, the
We'll
problem is
dismiss
we
it
are
for
in
default.
contact only with
We'll
petitioner
say,
number
we'll
1. Your
record
Lordship.
your submission. We say that you have difficulty in contacting the client and you could not contact the client for last 6 months. So it appears that the petitioner has lost the interest.
Lordship, the difficulty here is we are only in contact with petitioner number 1, Your Lordship.
We can understand your difficulty. It means the parties are also not interested to contact you.
Short pass over, Your Lordship.
It is pending from last. Let us see. We'll just verify and we'll record it and we'll say, we'll record your statement. You will not be blamed for that.
Lordship, another opportunity may be granted, Your Lordship.
You have enough opportunity. This court is not inclined to grant you any opportunity.
One more opportunity, Your Lordship.
See, your submission from 14 September 2023. Order dated 14/9. You appeared. Mr. S. Karim, Landed Council. You appeared, you see it. And you submitted that you may be allowed to take steps for substitution of the deceased petition. So from September, if you cannot do it, then we'll say that you do not have any interest. There is enough. We'll record that you failed to.
One more opportunity, Your Lordship, may be granted. Let it be the last opportunity, Your Lordship.
Enough opportunity. After giving more than 6 months, what more is there?
Lordship, I humbly prayed for a short pass over, Your Lordship.
It cannot be then. Yes,
It's up to the court,
up to the court.
sir.
So we will not tell what the court should do.
Up to your discretion, Your Lordship.
This court is not at all inclined to grant it. Not
My
at all.
apologies, Your Lordship.
This kind of conduct is not at all appreciated.
My apologies, Your Lordship.
See, every now and then you ask for 1 week time, 10 days time and all, and then you do not do it for 6 months.
Lordship, I tender my sincerest
This is
apology, Your Lordship, before
something
this
not very
honorable court, Your
appreciated.
Lordship.
This court doesn't appreciate that. You take longer time, you take time twice, and then you do the needful. There is no use of, you see, taking time for 1 week and 2 weeks and all. Make it, just keep it pending for 6 months and do not do. So the request made by Mr. S. Karim, learned counsel in appeal of the petitioner. Further 1 week time is granted as a last chance for filing of application for striking out the name of the petitioner. Number 1 in the matter. List after.
Item number 5.
Yeah, please, Your Lordship.
Yes.
I pray for 2 weeks' time, Your Lordship.
Why?
Conducting counsel is on sanction leave, Your Lordship. Conducting counsel is on sanction leave.
Who is conducting connection?
For this respondent number 5 and 6. MM Kurisi.
Yes.
So, yes.
Item 5. You just say a request has been made on view of the respondent number 5 and 6. Made by so and so. Appearing on view of the number 6 to adjourn the matter on the ground that the conducting counsel, Mr. Anur Kurisi, is out of station. Mr. S. Sheikh, learned counsel for the petitioner, has no objection.
Item 5.
Wait. The court has not passed the order. That should be finished. There's no objection. When do you want it?
2 weeks after 2 weeks. Your Lordship.
Prayer allowed. List after 2 weeks. Yes.
Item number 6, Lordship.
5, 6, and
Item number 6. That Mr. Hazarika is appearing for the private respondent, Lordship.
Respondent 6. In item 6, Lordship, I'm appearing for respondent number 6.
No. Item 6, who is petitioner?
Time for the petitioner, Lordship.
Item 6, nobody is asking for time.
She is asking time, Lordship.
Item 6, you say
At the
on the request.
respondent 6.
At the request made on behalf of the respondent number 6, list is matter after 2 weeks. List the matter after 2 weeks. And then
Then item number 7.
Item
The respondent, same respondent. 8.
Item number 8, Your Lordship.
Item number 8, I'm the petitioner. Your
item
Lordship.
number 8 also you are there.
Yes, respondent.
So you are
I'm praying for item number 8, Lordship.
8. No,
Respondent.
earlier that order which filed, that was
So, item number 5.
that was item number 5. Now item number 8.
8.
Item number, you are appearing for respondent number
5.
5. You just make it the same order, but then make it respondent number 5. Item number 8 after 2 weeks. Okay. Then who is for petitioner?
I'm
Okay, just item 8. He's the petitioner. Okay.
Highly obliged, Your Lordship.
Item number 7.
Please, Lordship,
Yes.
I'm on behalf of the petitioner. Mr. Naklau is in another courtroom, so he instructed me to come before
Argue
the
the
annual
matter. He
decision.
instructed you to argue the matter.
No,
Why?
come before
He
the annual
told you not to do the
decision.
matter.
He'll do, he'll do himself.
But then in such a case, it should be taken up now. You can open up the case.
I don't know much about the case, I don't know much about the case.
The brief is there with you, isn't it?
Yes,
Yes. What is your prayer now? What you are praying for?
No, this matter is regarding seniority, my lord.
Yes.
As such, there is no urgency, my lord. You can come next week also.
It's okay,
Just at the joint request of the parties, so this is matter.
Item number 9.
My lord, this case, my lord, I am praying for some accommodation, my lord. My lord, what has happened, my lord? I heard that some development is taking place, my lord, post-election. My lord, that is what I heard, my lord. Because this honorable...
Post-election development.
My lord.
What kind of development?
My lord...
this matter is what? Pertaining to what?
My lord, this is pertaining to...
Goodam, your lordship. What happened?
Oh, this is not a construction matter. Not
No, no construction, my lord.
construction.
I am occupying, I am running a shop, my lord. A sweet shop, sweet meat shop, my lord. I am running for the past 30 years plus, my lord. Now, my whole livelihood depends on that, my lord. So, my lord, because to my information, my lord, there is some things are moving forward right now, my lord. That
No,
the municipality.
You have approached this court for what?
My lord, they had issued a notice to me to vacate the shop, my lord, stating that the
This is a leasehold premise.
Yes, my lord.
It was leased out for how many years?
30 years, my lord.
30 years. That expired. 2019 expired.
So thereafter you have
as
not
per the
renewed it.
clause 12 of the agreement, he should have handed over to us.
There was an agreement.
Agreement.
Okay. So the time stipulated therein expired.
Expired.
But even then he is not.
No.
And why you are here? Go to civil
But
court.
he has not stepped in the agreement. How he is coming into the court, I don't understand. No locus standi.
My lord, the shop was in the name of my father, my lord. Thereafter, my lord,
He was not a party to the agreement.
No, my father was, my lord. And my father expired, my lord. I have filed a representation stating that you kindly issue a fresh agreement in my name. My lord will kindly see even in the municipal areas.
But then are they duty bound to do that? Just because you make a request, are they duty bound to oblige it? Say, is there any legal right vested?
My lord, because ultimately, my lord, if I am not there, let's assume a situation, my lord, then someone else will be there, my lord. I am ready to pay whatever is required. I am ready to pay because my whole livelihood depends on that, my lord.
No, this is a very old Goodam number 31 and 32. What happened? There is a clash between this family. His wife also filed a case earlier. There's a clash. I don't understand how this Contempt came into being. So who is Contempt also we do not know. And his death occurred in long back.
My lord, I am the son. My lord, that is incorrect.
But there is infighting in their family.
No, it is not.
Civil suits were there. Civil suits.
Let us hear. You will have your chance. We are right now. We are not treating anything as gospel truth. We'll see the records and then we'll say.
So there was a civil suit filed by his wife and
this Khongtaram's wife.
Yes.
This Arindam, his wife.
Maybe somebody else. We do not know that. And he died, Mr.
And then this petitioner is a party in that suit.
No, not this petitioner. We do not know who is the petitioner.
What is the understanding of the petitioner then?
My lord, I am in occupation of the shop. I am the son. My lord, I am the son.
How you came to occupy the shop?
Right from the time of my father, my lord. Earlier, my father was running the business. Thereafter, I am running the same business, my lord.
The holder of the lease was your father?
Yes, my lord.
Then civil suit was filed by?
By his wife.
Whose wife? This present petitioner's wife?
Yes.
The present
petitioner's not wife.
Correct, my lord.
I'll just interview. Your lordship will see. That was filed if your lordship comes to my written statement, your lordship, yes, everything will be clear, your lordship.
And what is the situation of that suit? What is the position?
Dismissed. The suit were dismissed. And under surprising part now, we have discovered that his father died long back. And that was never intimated to the board.
That is incorrect, my lord.
No.
That is absolutely incorrect. My father went missing. My lord, presumption of death will only have to occur after 7 years. FIR is there, everything is there, my lord. Police report is there. The board is also intimated. That is incorrect, my lord. And I have, my lord, they have been receiving money all these years from me.
When did your father disappear? Which year?
Date of death is 8/10/2099.
99. So
2019 lease expire. And how Contempt came there also we do not know. And Silpi, who is Silpi? Silpi claimed that she is the wife
of
Mr. Ajay Kumar Datta.
that means this Ajay Kumar Datta was the leaseholder, original.
Leaseholder means
he was
it was allotted in his name.
He was the
Guda was
allotee.
allotted.
He was the allotee.
He was an allotee of the Guda.
And then this lady, what you said, Shilpi,
yes.
Shilpi or what? Anyway,
So, I shall just come to that.
that she filed the civil suit.
So she filed a suit,
Yes.
your lordship. Then suit was dismissed.
She filed a suit praying for what? Suit was
Praying
filed
why?
for-
Because he was a defaulter. He could not pay the rent from 1988. All these things happened. Then she came to rescue him. Then she became a partner together. Both were allotted in the joint name of the.
No, that is incorrect, my lord.
No, your own affidavit
Things are
says.
becoming quite
These are all disputed question of facts.
No,
In fact,
my lord will kindly
he
say.
has some
No,
alternative.
at least we should get the picture first. Now,
Yes.
who is the original allotee?
Original
What's the name of the
LOT,
original
if your lordship is pleased to come, I'll just my affidavit in opposition. Your lordship.
My lord will have to look into my writ petition, my lord.
We'll definitely come. We are trying to get
Original
the,
is Sri Ajay Kumar Datta and Srimati Krishna Das Bhomik.
It was allotted in joint name. It was allotted to two
joint
persons.
name. First initially Ajay Kumar Datta, then Krishna Das Srimati C came in to rescue him. That was he was a defaulter for quite long, from 89 all this thing.
He
Then
was a
she
defaulter.
paid,
What about the other partner?
then prayed before the board to
No. You see, you said that it was allotted to two persons.
two persons. Initially, it was allotted to Ajay Kumar Datta, but he was a defaulter. Then, since he was a defaulter, he said, "I'm unable to pay the rent, so kindly incorporate
Krishna Das.
Krishna Das Bhomik also along with me in both these stocks together."
So Ajay Datta and Krishna Das, they became joint.
Jointly, means
Joint allotee.
allotee for this.
And then they carried on.
Yes. Then it was
Then where from this suit came?
suit came. Your lordship would see
When
that was filed.
suit was filed against what action?
Silpi is.
What is the cause of action in the suit? What is the prayer in the suit?
Krishna Das, Srimati Krishna Das Bhomik, she was a plaintiff and Ajay Kumar Datta was a defendant before Assistant District Judge at Ceylon. Title suit number 3H of 2001.
Suit was filed by
My lord, suit was filed by Krishna Das Bhomik.
Srimati Krishna Das Bhomik.
Who was one of
joint
the
allotee.
joint allotee.
Joint allotee.
Now
That suit
appeared
was
means
dismissed.
that there is a dispute between them.
Dispute between them.
So she
how,
filed a suit.
how Contempt come into, there's also another.
Now then that suit was dismissed.
Dismissed, my lord.
So
That
it
was-
has lost its thing. You see. So this present issue is not connectable to the issue
No,
which was
not at all, my lord.
pending in the suit, isn't it?
Yes, my lord.
Then again another suit was there, KD Bhomik.
That is also Krishna Das Bhomik, my lord.
This was Bhomik. That
That
was
suit
filed
is
before
dismissed.
Munship at Ceylon in 2003 against Silpi Datta. Silpi Datta is the wife of Ajay Kumar Datta.
And what is that suit about?
That is also with regard to dispute between the themselves.
My lord, there is nothing on
What
record.
was the subject matter precisely? These are whether those subject matters involved in the
We are
suit.
not concerned with the dispute. Whether family dispute or their internal dispute, we are not concerned.
So those suits has no relevance. Suits
Yes.
have no relevance so far as this proceeding.
No,
Yes, my lord.
not relevant.
So let
Because
us forget it.
They were not included in the, only as per our record, what it says, your lordship will say that at page 29 of our affidavit in opposition, let me come straight to handing over, taking over, Krishna so-and-so, so-and-so. Yes. Page 30. I'll come to page 30 directly, your lordship will see.
Yes.
Page 30, Annex 10 of my affidavit in opposition, your lordship. Lordship got that?
Yes. Yes.
Leasing of cantonment godowns, survey number so and so, So your lordship will see, this is to inform you that the cantonment Godown number 32 in Suburban of Shillong Cantonment is allotted to you on lease with effect from 19 May 1989 for a period of 30 years at your quoted rent of rupees 2,500 per month for the first floor for the first 5 years, subject to revision every alternate 5 years. You are required to execute a lease agreement of Godown allotted immediately. This has been given to Ajay Kumar Datta and Krishna Das Bhumi and Ashok 10.
How this petitioner is related to this?
No, we do not know how petitioner is related
This petitioner is Khongtorem, isn't it?
Khongtam.
My lord.
Now, Khongtorem is who? How he is related to these two persons?
My
Ajay
lord,
Kumar Datta and-
Krishna, I will tell, my lord, what is the fact. My lord, how
Just
Krishna...
tell us how he is related.
My lord, Ajay Kumar Datta is my father, my lord. My mother is, my lord, if my lord kindly goes to my petition.
Khongtorem is a local tribal surname, isn't it?
Yes, my lord.
So it means the
My
mother is-
father had, my lord, earlier his wife was Shilpi, my lord, Shilpi Datta. Subsequently, he married again, my lord.
So anyway,
Now,
whatever,
as far as
whatever
the shop
you
is
see, we
concerned, my lord.
do not have to go to those
My lord.
details. You are saying that your son from
On the
second
wife, maybe.
Yes,
We do not
my
know
lord,
that.
my lord,
Your
in
son
my
from-
cost title
your
it is
son
written.
from a second wife.
Second wife, my lord. Earlier wife, to my
Now,
understanding, my lord,
can you be treated as a legitimate?
my lord, yes, my lord. And as far as earlier
Then
wife is
more
concerned, my lord,
complication will come.
my lord, as far as earlier wife is concerned, to my knowledge, my lord, she did not have any issue.
No, that is okay. We are not at all concerned with those things, whether issue is there. Now, if you want to say that by virtue of yourself being son of the original LOT, you step into his shoes, then the question will come, how much you can inherit, what right of inheritance you have.
My lord, as
That is your legal thing. We do not
children
know.
will have all right of inheritance.
Hmm?
As far as children are concerned,
Whether
my lord.
legitimate or illegitimate, you will have all.
Yes, my lord.
Provided that you are proved to be a child.
My lord, my birth certificate, which I have included.
Are you disputing his locus standi in
Yes,
this?
yes. We have.
What stand you have taken here?
We have taken the stand. Your lordship will
But
see.
my lord, as when it comes to receiving the rent for all these years, they have no issues, my lord.
No.
Cannot blow hot and cold at the same time.
Anyway, just wait. Do not get impatient.
My lord.
See, just tell. Let us just. We are trying to get. You see, we remember the prayer you have made for her during the. Okay, so that is there in the mind. But then just trying to get the thing. If we can finish the matter, if it seems to be a small issue, then why not?
My lord, in my rejoinder, I have put my, I have placed my.
Okay, we'll come.
My
to
lord,
that.
birth certificate.
What is the objection to the locus standi, Mr. Mohanta?
That your lordship, from the middle of the page, I don't want to trouble
Page?
your lordship. Paragraph 7, we have stated about the allotment. Your
Yes.
lordship, page 3 of my
Yes.
opposition. Paragraph 7, if your lordship comes, if I'm permitted to read, that answering respondent, while denying the characters or estimate in paragraph 3 of the answering respondent, states that as per record and so also as per the said lease deeds, NHA 1 of the read petition, that said cantonment Godown number 3132 still stand in the joint name of Sri Ajay Kumar Datta and Srimati Krishna Das Bhumi, and not in the name of the petitioner, as transfer has not been affected in his name till date, nor the name of the joint LOT Srimati Krishna Das Bhumi has been deleted till date, and no application or information for transfer has been submitted to the cantonment office.
That is incorrect, my lord. I have submitted an application.
Further, the answering respondents state that initially by so-and-so 88 and so-and-so 1988, 2 numbers of godowns were allotted to Sri Ajay Kumar Datta against his tender auction bid dated 18/1/1988 for allotment of 2 godowns to be constructed with advance rent to be paid by the LOT in 4 installments. However, the said LOT Ajay Kumar Datta defaulted in payment of the second installment in time, and for which the cantonment board had issued 2 notice board dated 35/1988 in respect of the 2 godowns, and again the said LOT Ajay Kumar Datta defaulted in payment of the second and third installment in time, and for which the cantonment board has issued 2 notice board 49/88 in respect of the 2 godowns to the said Sri Ajay Kumar Datta, and again the said LOT Ajay Datta defaulted in payment of the installment in time. and for which the Cantonment Board had issued another notice 13/12/1988 to the said Ajay Kumar Datta. Thereafter, Sri Ajay Kumar Datta, via his letter dated 15/8/19, addressed to the Chief Executive Officer, had himself requested for amending the allotment in the joint names of himself along with Srimati Krishna Das Bhomik, as she would be rendering financial assistance towards the cost of construction of the said two godowns. Hence, on the sole request of Sri Ajay Kumar Datta, the cantonment by two separate letters, both 17/5/1989, in respect of the two godowns, had informed Sri Ajay Kumar Datta, Srimati Krishna Das Bhomik, that the said two godowns number 31 and 32 have been allotted in their names with effect on 19 May 1989, and requested them to execute the lease deed for the same. Accordingly, the said two godowns were handed over jointly, and in fact, Sri Krishna Das Bhomik had duly signed the handing over and taking over dated so. Thereafter, two separate lease deeds for the said two godowns were executed in a joint name as Ajay Kumar Datta and Srimati Krishna Das Bhomik. Annexure 1 to the petition, which for 30 years, ending on 18/5/2019, and which term has now expired. Further, answer also stated it is a fact that one letter dated 28/5/1997 was received from Sri Ajay Kumar Datta requesting for deletion of the name of Krishna Das Bhomik, but deletion was not done as no consent or letter in this regard was given by the co-allotee Srimati Krishna Das Bhomik for deletion of her name. Hence, for all purposes, the said two godowns stood in the joint name of Ajay Kumar Datta and Srimati Krishna Das Bhomik. Thereafter, as per the cantonment records, two title suits were filed by Srimati Krishna Das Bhomik in respect of the said two godowns against Sri Ajay Kumar Datta, being title suit 3H/2001 before the Court of Eastern District Justice Law, which was disposed of on 13/8/2014, and title suit 54H before the Court of Munsim, which was also disposed of by order dated 14/12/2010, and those suits were caused by one Shilpi Datta, who represented herself as a wife of Sri Ajay Kumar Datta.
So Ajay Kumar Datta was not available at that point of time.
No.
So Shilpi Datta, who claimed to be
His wife.
he defended him in those suits.
As per the death certificate they submitted now, it shows that he expired in 1999.
But then he said,
My lord will kindly see I am not in there in the case.
Yes.
My lord, as far as the Shilpi Datta case is concerned, my lord.
No. See here, what it says, if it is accepted as correct, we are not saying it. We will definitely have your version. Now, what we can gather from here is that in those two suits, one Srimati Shilpi Datta defended the suit, being wife of Sri Ajay Kumar.
My lord, if I respect.
So it means this Shilpi Datta was the wife.
Was the wife and step in that suit.
Lord,
Now, where this Shilpi Datta is now? She is not a party here.
Not a party. We do not know.
So Shilpi Datta has no claim so far as these things are.
My lord. My lord, what, in my respectful submission, my lord, what may have happened, my lord, is that must be that earlier, my lord, because the case records are not with me. I have never gone through also. What might have happened, my lord, earlier, my lord, Ajay Datta may have been made a party, my lord. Subsequently, maybe she was substituted.
If she is substituted also, that is basically is a proof of her assertion that she is a wife. Isn't it? So if she is the wife, then you are not. You are not.
No way in the picture.
You are not son of Shilpi Datta.
I am not son of Shilpi Datta. My lord will kindly see the cost title.
Then how then? That means now then the question will come. Then how you come into picture?
My lord will kindly see my cost title. My lord.
Anyway, but then you have not challenged his locus standi, Mr. Mahan.
No,
there is no challenge to his locus standi.
We have said. It is said that the revises of 5 years. We have stated.
My lord will kindly see my cost title. My lord, read petition, page 3, my lord.
Further answer is at page 7. We have
We can decide this matter, I think.
My lord, I am praying for time only on my lord. What, lord? The only thing is that, my lord, it seems
we
that
have to just see the legitimacy.
If the municipality, my lord, if the Shillong municipal takes over the administration, my lord, I may stand a better chance. In fact, my lord,
why?
There are several other.
The officers there are. They are more in your favor or what?
They not that, my lord, but at
See,
least a
we
question
are-
of
we
renewal
are-
will be there, my lord.
we are on a legal issue, isn't it?
Yes.
What is your page 3 of your petition?
My lord, page 3, my lord, will kindly see the cause title, my lord, in the matter of Shri.
Not page 3, this is synopsis. Then,
Page 3 of the writ petition, my lord. So here I have clearly declared, my lord. Arindam Khongtaram, son of late Ajay Kumar Datta, and Srimati E. Khongtaram, resident of Maidan Laban, Shillong, POPS.
Anyway, Mr. Mohanto, you have not denied that he is the son of Ajay Kumar Datta anyway.
My lord,
I said that.
and my lord, in my
10 I have
rejoinder,
said.
my lord,
There is nothing.
my lord,
I've
if
said
kindly
it.
takes
I've
a
said
look
it,
at my
your
rejoinder,
lordship
my lord,
will
page
see.
15.
Whereas there is a
take
question whether
the-
petitioners, your lordship, I've stated. We don't know. If Ajay Datta died in 99 as per the date certificate now they have given in the petition, Cantonment was never informed.
That is not true, my lord.
See, if in your reply to paragraph 3 of his petition, you have not denied that his petition is not the son of.
No, at page 7, paragraph 10, I have
No,
stated.
but then there is a specific
yes.
assertion by in his writ petition. That
See, your
petitioner is
lordship
son
will
of-
see. No, I have stated. In reply to a statement made in paragraph 6, 7, 8, 9, and 10 of the writ, the answering respondent makes no comment. However, with respect to Sri Ajay Kumar Datta having gone missing and his subsequent date, further the answering respondent state that they are not aware as to who is the legal heir of Sri Ajay Kumar Datta
That is a
and whether
different issue,
petitioner
but
is the son of one of the LTC Ajay Kumar Datta or not. And as such, the said statements are subject to proof thereof. And as much as earlier, before the civil court, two civil suit in respect of the dispute between the two LTCs were being
There is
contested
no
by one
specific
civil.
denial, Mr. Mohanto. These are all evasive denial. Now, if you come to his writ petition in paragraph 3, he has made a categorical statement. The petitioner is the son of late Ajay Kumar. And now, if you come to your reply of paragraph 3 in your thing, you have not denied it. Writ petition, page 4, paragraph 3.
There we have said, not in the name of the petitioner as transfer has not been affected.
That is okay, but then you have not denied that he is not son.
Whether son or not,
We
that
are,
he
we
has
are
to
on the
prove it.
question whether it is son or not.
So,
It is
nothing has
admitted
come
that
to
it
us.
is not been, there is no allotment to his. He is not
no, not
saying that.
allowed, not allowed. Therefore, no locus standi. Yes, so, okay.
No, that is what is to be seen. Now, your claim is what? For what? In this writ petition, what you want?
My lord, my prayer is, my lord, that my lord, the lease, a fresh lease may be issued in my name, my lord, and I am ready to pay whatever
Now,
is
whether
required,
your
my lord.
prayer is backed by any law, is there any law which says that the preferential treatment should be given to you when it comes to
My lord,
the allotment of lease?
my lord, firstly, my lord, I am already in the occupation, my lord. I have been running business for a very long time in that said premise itself. I have been paying rent.
Any law to support your contention that since you are in possession, that it should be allotted to you.
Of course,
We are in Article 226, isn't it?
Well,
Enforcement of your legal right.
but as
Or
far
the
as
Constitution.
that aspect is concerned, of course, today I am not
So,
ready.
if you say, if you're in a petition under 226, if you want to assert your right, then it has to be backed by some law, isn't it?
Of course, today I do not have it.
Now, if you say that being the existing allotee, being in possession, being in occupation of that you must be given a preferential right. In such a case, place this law and get the order. we'll direct them to settle it in your favor, provided you are ready to pay the.
Yes, I'm
thing.
ready to pay, my lord.
If you can show that you should be given a preferential, being the existing lease, even if we discard his objection that who are you, okay, if we take that statement as correct that we treat you as a son of so and so, okay, and then we say that being son and being occupation and enjoyment of these things, you have a preferential. No, but then for saying that we have to have.
My lord, as far as this son is concerned, my lord, in my rejoinder, page 15, annexure 1, my lord, I have enclosed the birth certificate, which I took out in 2005.
It's all right. We assume that you are son. But then you show us, then you have to be a preferential.
Well, of course, today I do not have it, my lord. So
that is the main basis of your claim. If your contention is not backed by law, can a
Yes.
writ court order settlement in
Lord,
your favor?
as far as, my lord,
Now, we cannot go by sympathy
no, my lord, not
or
a
other
question.
emotional consideration.
My lord will kindly appreciate, my lord, even in the revenue lands, my lord, which belongs to the government of Meghalaya. My lord, after expiry of lease,
See,
it
there
is
comes
always
to-
renewed,
see,
my
it
lord.
is all right. There is a heritable right. It is a transferable and heritable. You do not have a transferable heritable right. Different. It is yours is totally guided by agreement which you execute.
But my lord will kindly appreciate, because my whole livelihood depends on this. Now, suddenly after 30 years, if I'm told that,
Can we go by those considerations? You show us some law. It is not that you see the court will give you some benefit, okay,
Yes,
from
that
its
is
own
the-
thing. It is something, a benefit you are claiming by virtue of law. So you have to show us, please.
my lord,
Law.
that aspect I'll look into, my lord. I'll try to get some law citation.
What is to be done, Mr. Mahato?
No, but this is all disputed question of
If
facts.
you
In
have to
fact,
allot it to somebody, why do not consider him?
No,
if
no,
he's,
no. Your
if he's ready
lordship.
to pay the rent which you are demanding, what is the problem in it?
No, problem is that in all the godowns we want to renovate, everything has to be reconstructed.
But then does it mean if you give it that will not be cannot be renovated?
No, because not only this godown, all the godowns, all other civil suits were
all
filed.
other godowns.
No, those all civil suits were filed. So my condition that he got other alternative remedy to go. He's not taking the other alternative. All other godown holders, they are filing a civil suit that is pending. That is going on. Because we do,
My lord,
against them also we give the unauthorized occupancy act,
My lord.
illegal occupancy.
My lord, as far as-
So PP have gone, then thereafter they have gone on appeal also before district judge. That is so pending, Your Lordship. All other godowns.
So there is an eviction notice under PP Act.
Yes, yes.
And then they have challenged it before the court of the
Yes.
district judge, isn't it? PP Act is challengeable. to
Under
district.
section 9. Section.
Yes. So those will be summary proceedings, not like a suit.
That's right. That's right. So, and
But then there is no notice issued to him under PP Act.
no, not yet, not yet. Because since
Because this suit is in existence.
because he
this
got
case-
in this order, he got it. Otherwise, we
and
supposed to
this all the shops for which this
godowns,
notice were
all the
issued and
godowns.
of godowns.
Actually, this 31, 22.
Basically, now you want to renovate it.
We want to renovate all
So
these
now
things.
for
And we want to
renovating-
renovate, we want to auction it again. Re-auction it.
For renovating,
Re-auction.
you want vacant position.
Vacant position because we'll re-auction the whole godowns.
So your purpose is basically to evict.
So we'll re-auction that. Said we are given right of preference also. We are given right to match. We are given, and two of them they took per square feet at 96 and 95 rupees. They were allotted. They are paying those, and the others they don't want to pay. Therefore,
In fact, my lord,
Then he said he is willing to pay.
in fact, in fact, my lord,
let him approach.
in
Let
fact,
him
my
approach.
lord,
We don't
I have
let
already
him
approached, my
approach.
lord. In fact, my lord, I was paying without any objection, my lord. They kept on increasing the rents. I've been paying accordingly, my
It has
lord.
been said by the senior council that 2% have been allotted because they are willing to
Oh,
pay at the rate
pay
specified by
95,
them.
96 rupees. Per
My
square
lord, I
feet.
have already
So-
approached. My lord, I have already approached, my lord. Will mildly kindly see my representation, my lord. I have clearly said that whatever amount, my lord, I am making the submission today, my lord. Not
Why,
only that.
Mr. Mohanto, why don't you help him? Let him explore the
No,
possibilities.
if he approach the authority with that 95, 96,
what,
then,
what you will get by evicting him if you get the same rate which
No.
you are expecting from him?
No, obviously not. But we do not know who is Contempt. This is another thing also. They should have intimated. And when he wrote a letter.
There is no other claimant so far as this
Yes.
are concerned.
Yes, my lord.
And we did not know, even that
No,
we
no one
took
else
out a
has-
copy later. Subsequently, after he filed, and we took out all this.
No, my lord. Because my lord will kindly see from the record. If they go through the record, my lord, all these years, who is paying the rent? My lord, we are paying the rent. No one else.
No.
Yes, my
All
lord. As far as
accumulated, your lawsuit now.
What is your existing rate?
As, I think they are paying
Tell
at
us, can you-
2,500.
Can you inform us? We'll pass some order so that your authority can consider it.
All right, then I can.
We just, if you get the rate, and then let us see
Yes.
if he's agreeable.
All right, then I can.
Then of course we cannot direct them to these things.
Obviously.
But then we can just tell them to
Yes,
consider.
otherwise, they can participate in the auction. They can always participate in the auction.
That is another.
The auction is one uncertain part.
Yes, my lord.
If he has a ready standing business there, you see, just to, you see, basically close down it there and to start somewhere else afresh.
I understand.
That is something. And if your main purpose is to get the prevailing rate, and if he is willing to pay it, then you also get your relief. Why to fight it out?
Let me opt in the instruction.
At least this much.
To that part,
This much sympathy you can show him out of court, of course.
Yes.
He may not have a very
In fact,
legal
I
claim.
told him long back. All these things I told him long back, but he is not inclined to do.
No, my lord.
No,
I have
now
you-
since
and
he is
my client has been, my lord,
See, Mr.
eager
Bhattacharya,
for
you
settlement
do
right
not
from before.
expect that this court will pass a direction in your favor until and unless you can establish it.
No.
That is one thing. So if there is any scope for yourself to negotiate and come to a settlement, that would be the best
My lord, I have been.
for your
My
client's relief.
client was eager from right from the beginning, my lord.
Now Mr. Mohanto is there. You can take his help and just try.
I offered him long back.
My lord, because I have also requested, my lord, that
2019
kindly,
I
if the
offered.
authority. In fact, my lord,
See, it is coming from him only.
my lord, in fact, the petitioner had approached the authorities on several occasions, my lord.
Now Mr. Mohanto is there.
My lord. My lord.
Anyway, I'll
Just
opt in the
just
instruction.
try to do something. You see, like, do not expect. You see, like, this court is equally concerned about the fate that if in the event this case is dismissed, what will happen?
My lord.
If you at all have a running business.
Running business, my lord. And it's a
Now, that is
established,
what-
well
that is what-
established business.
See, but then when it comes to deciding something in accordance with law, then you may have difficulty. So why not, if there is an opportunity to negotiate and settle?
My lord.
Explore that part.
Yes, my lord.
When shall we have it?
And yeah, I'm ready. I can opt in instruction now. Also, I can opt in. It's up to
Let
him.
it come after 3 weeks or 2 weeks.
No, after why? Yeah, the senior counsel is giving you indication. You see, settle it, and if you therefore you fail it, and do not expect any sympathy from the court.
No, my lord. We will.
If there
be
is any
interested.
kind of, you see, the inclination shown by the allotting authority, then
Yes,
you
my
should.
lord. We are interested in settling.
Now he says. Anyhow,
Yes, on the request of the petition only. We'll give you 2 weeks time. Yes,
my lord.
I'll opt in instruction.
If possible, you do it. See, you are not basically, you cannot also travel beyond certain things. But then if it's possible, if you are looking for
I'll
something,
try to
somebody
opt.
suitable,
Because I'm agreeable.
and if he's suitable, then
No, now he said he is agreeable.
I was always agreeable. my lord.
So you see, there is no use expressing it before the court.
My lord.
You should go and express it before the authority, who would accept. And now Mr. Monte is there; he may help you.
2 weeks.
My lord, I'll call up my client. my lord. Obliged.
Item number 13. This matter, my lord, the respondent was supposed to place instruction with regard to, my lord, the grounds on which PW1 was recalled, my lord. My lord has heard this matter on the last occasion. This is
Oh, this is this case where no reason was assigned.
no reason was assigned, my lord.
So,
So, my lord,
what for they need to take instruction as to?
on what ground they have been, the PW1 was recalled, my lord. That order allowing PW1 was.
My lord, we cannot go beyond the record, my lord. As of now, my lord, whatever is before your lordship, my lord, the petition filed by the prosecution as well as the order of the learned
No,
judge.
see, Mr. Guru, what happened that the petition basing on which the trial court passed the order, see, there is nothing mentioned
Yes.
about what for this person is to be recalled. It is not that you are calling a witness who was not at all examined. You sought to recall a witness who was already examined.
Yes.
Okay.
Yes.
Now, when you recall somebody who was already examined, then there must be some basic purpose for which
My lord,
this person was sought to be recalled. Now, that is what was the purpose? That is especially the query of the court. Now, tell us what is the purpose.
my lord, it is reflected in the order of the learned trial judge. It is there. Both the sides were heard at length. Evidences were being produced. Thereafter, he has come to a finding that yes, it will be required.
And it will be required for what? It will be required for re-recording the statement which are already there.
Re-examining.
Lord, he cannot be.
Re-examine, does it mean that you'll be again afresh? And what will what will happen to the earlier round of?
No, my lord, I'm handicapped man that way, because what is the reason being cited by the public prosecutor here, my lord? That is not there. Now I cannot go beyond that. But eventually, my lord, the trial court has, my lord, cited the reasons there. And I don't see any defect.
Trial court has given a general kind of reason. There's nothing specific.
Yes. He is not required to make a very elaborate finding on that.
At least there has to be purpose has to be recorded at least. What purpose is this thing?
Kindly see,
In
my
brief, my lord, there is a judgment which says that in brief, at least they have to record what is the reason.
Yes, brief. It is there.
No, my lord.
It is very much there.
Who was the witness who was who is
PW1, the complainant, my lord.
Complainant.
The complainant.
PW?
1, my lord.
The deposition is here?
Yes, my lord.
Where at what page?
My lord, at page 29, my lord.
Now, what the confession statement as the accused has to do with the recalling of this person?
My lord.
This person has nothing to do with the confession of the accused.
My lord.
This PW1 is not the officer who recorded the statement.
Hello.
Neither the maker of the statement. So what this confession statement of the accused has to do for recalling of the witness?
Now, my lord, I'll have to travel beyond, my lord, the record if I have to satisfy your lordship. What has happened, my
lord? The purpose.
Yes, my
the
lord.
purpose,
That will be off the record, my lord, because it is not here, my lord. It is not here in the record. Personally, my lord, I had contacted the PP there, my lord. So I wanted to know. This is the query of the court. So, my lord, it appears that, my lord, the complainant, in her examination in chief, my lord, she more or less contradicted with her own complaint. Then, but my lord, that particular at the time of examination in chief, my lord, so she was examined and sent off. Subsequently, it was learned that the accused here and the complainant, they are living together. That was the reason why she had, my lord.
Now, which way prosecution can improve that?
Yes, my lord, this is not a lacuna.
So
this is not a case of lacuna,
have
my
you
lord.
declared that witness? You are recalling that person for
lord.
declaring that person is hostile?
No, my lord, there has
No,
not
no,
been
we
that.
have not. But my lord, this is a subsequent development, and my lord, I am entitled to, my lord, rectify that error. It is not a lacuna.
What is the error?
The error is that, my lord, the public prosecutor out there, my lord, could not put the questions which were supposed to be put, because that particular, my lord, episode was not known to the public prosecutor, my lord, at that point of time, which was subsequently, my lord, it was revealed. So therefore, my lord, I am entitled.
Now, how it become relevant for the purpose of establishing prosecution case? Prosecution case has to be confined to the facts which happened
Yes.
at the time of the occurrence.
Yes, my lord.
Then-
Now the case of the prosecution case is that, my lord, at the time of examining the, my lord, PW1, the
Let us
complaint.
you just come to the reason cited by the High Court. The last paragraph. What does it say? It's a very small thing. You can see. Come to page 44. Page 44 of the petition. Just see the last paragraph on going through.
I have read it, my lord. On going through the recorded evidence and the statement of the complainant under section 161 CRPC, also the confessional statement of the accused,
Yes.
which learned PP submitted,
See,
will also be filing application for recalling the recording statement. Is seen some essential facts requiring to be extracted from the complainant in order to enable the court to reach.
Says not
reach-
some essential facts.
No, please
It
let
should
me
not-
complete. So this is good enough, my lord, to enable the court to reach at a just decision. My lord, that is
reach at the just decision. You see, it is not that. That is why this court, at the very beginning, wanted you to take the point of the fact that the person who is sought to be called here is not a fresh witness.
It's not a fresh one.
It's a recalling of the witness.
Yes.
This is a difference.
Yes.
Now, had it been for a person who was not at all examined, this reasoning could have sufficed, could have served the purpose. But then, once you decide to recall somebody, it cannot be for the purpose of covering a lacuna. Of the case.
Lordship, no,
that is what.
I beg to differ, my lord. This is not a case of lacuna, my lord. This is not a case of lacuna. Yes. Lacuna is something which is inherent weakness in the case of the prosecution. This is a case where error has been committed, my lord.
What is the difference between error and lacuna?
My lord, error is, my lord, in my humble understanding, my lord, error means those mistakes, my lord, that the prosecution committed, or due to the, my lord's carelessness of the prosecution.
Lacuna is also same. Lacuna
Those,
is also
no,
outcome of
my lord.
carelessness.
Lacuna is a gap, my lord. Lacuna is a gap which is created because of, my lord, there is an inherent weakness in the case of the prosecution.
This is also a fault. Lacuna and a fault has.
My lord, I'll bow down to my lord's.
No, there is no question of going down.
Yes.
If you have.
I have done a thorough research on this, my lord. So, because we had been, my lord, time and again, my lord, hearing on this point alone, my lord. So, my lord, I cannot improve my case, my lord. That is on my respectful submission, my lord. I cannot improve. I cannot go beyond the record, my lord. Admittedly, my lord, the prosecution there, my lord, I have not cited any reason in the petition, my lord. But my respectful submission would be that the reason cited by the learned trial judge, my lord, is sufficient enough, my lord. That is my.
What is the decision you are relying upon, madam?
Sorry.
Which paragraph?
My lord, it's para 17, my lord. May I read, my lord?
Yes.
The aim of every court is to discover the truth. Section 311 CRPC is one of many such provisions which strengthen the arms of a court in its effort to unearth the truth by procedure sanctioned by law. At the same time, the discretionary power vested under Section 311 CRPC has to be exercised judiciously for valid and strong and valid reasons and with caution and circumspection to meet end of justice, my lord.
That is a general.
There has to be a valid reason, my lord.
These are general propositions. Now, what this court is looking for basically is with regard to the difference of existence of situation when it comes to recalling a witness who is already examined and calling a fresh.
My lord, similar.
What are the different yardsticks to be applied?
My lord, in recalling a fresh witness, my lord, he can be examined entirely, my lord. But in only recalling a witness which has already been examined, they cannot examine him entirely, my lord. That there has to be a reason, or a specific reason he has to be examined, my lord.
That is what. So where is the proposition of law with regard to that?
My lord, a similar provision is, my lord, there in section 138 of the Evidence Act, my lord. There also, my lord. So this 311 has to be read, my lord, along with
In conjunction with that 138.
My lord, there also there is a provision for recalling the, my lord, witness. So, my lord, at the end of the day, my lord, my respectful submission.
Calling a witness and recalling a witness, there is a different thing, isn't it?
My lord, yes.
That is where the court is here. That is the point which has to be differentiated.
Yes, my lord. But
here it's a recalling.
Recalling.
Not calling a fresh witness.
311, my lord. The trial judges, my lord, if the trial judge finds that for the just decision of the, my lord, case.
You need to, madam, elaborate that part of so far as the recalling of witnesses. Yes, sorry. Sorry, you just.
No.
Sorry to.
So, my lord, the ultimate goal of the Honorable Trial Court, my lord, is to collect the best quality of evidence, my lord, and also which is, my lord, essential for to come to a just decision of the case, my lord. So, my lord, though the trial court has not passed a very elaborate order, my lord, but my respectful submission would be, my lord, there is enough, my lord, the wordings in the order, my lord.
See, Mr. Gurung. Now, witnesses sought to be recalled. What the trial court says two things on going to the statement number 161 and the
confession.
Of accused. Now, so far as the confession of accused, it is not at all relatable to this. We can say it. Now, coming to 161. 161 statement was in existence before this witness was examined.
My lord.
So these two reasons given are apparently not acceptable.
That is there, my lord.
That is, then if you say that the purpose is basically to find out the truth, the finding out of truth has to be in accordance with the procedure prescribed. It cannot be that the prosecution will be given repeatedly chance to improve on.
This is only the second time, my lord.
That is where the question
there
of
is a law that says, my lord,
error comes when the certain points are not at all touched.
Sorry, my lord.
The certain points of a criminal case is not at all touched while examining the same.
Yes.
You see, then you see, like you categorize that these parts of the evidence was not dealt with by the state witness. You recall him.
So, my lord, in that case,
you recall him. But then, if you recall somebody to again re-examine with regard to the questions which are put to the person again, that is something intended with.
That is there, my lord.
Like correct the lacuna.
I don't know, my lord, how the defense will be prejudiced. My lord, they will have ample of opportunity to cross-examine again on those phrase.
Defense will be prejudiced if you unsettle the very examination record in chief by your second round of chief.
That is in case of lacuna, if I understand properly, my lord.
No.
In case of filling of the lacuna.
No. If you again ask those same questions which were put to that witness before.
No.
Which the witness has replied it. Now, if we allow this, can we make a stipulation that prosecution will not ask the question which are already asked? Can we pass some sort of order?
Of course not. Of course not.
Then if you say that you want to re-examine somebody, with regard to what point? We are not saying that you divulge the detail.
Admittedly, that is not in the petition, my lord. That is not in the petition.
Give us something on that thing.
My lord.
Even my lord, I may be also.
Not this general kind of proposition.
My
These
lord,
are known. These are not disputed. Mr. Gurung will not dispute this.
My lord. My lord, may fix it on Friday, my lord. I'll try to place
Friday
some
is
judgments.
tomorrow.
My lord, on Monday. Need 2 days time.
Every time, my lord, I'll also, my lord, try to satisfy you.
Earlier, Mr. Thaba appeared here in this.
My lord, he is out of station today.
He was equipped with those things. He came with a decision on lacuna and error. And probably your submission is not with the line with his proposition of law.
This is bound to be some difference, my lord.
Let's say Miss R. Standard Counsel for the petitioner, Miss R. Dutta. R. Standard Counsel for the parties, huh? And Miss R. Dutta, Standard Counsel for the petitioner submits. The she needs further time to prepare the matter. Mr. Gurung has no objection. They're allowed list after a week. Just see something.
Next week, madam.
Yes. Yes.
Item number 15.
Yes.
May it please your lordship.
Yes, Mr. Chulai.
Lordship, this is an 482 application challenging the order passed by the landed magistrate, your lordship, allowing the accused to recall of the witness which was already examined for recross examination. Lordship will find it the order at page 24.
Yes.
Lordship will kindly come to page 27.
Yes.
Lordship kindly come to this court, being mindful about the judgment of the fact and circumstances of the cases of the opinion that the application so and so require constitution of the very valid reason that PW2 was the village secretary as well as the secretary of the VWSC when the alleged missing of fund took place, and he admitted that the fund can be withdrawn only by the accused person and him, who were then the chairman and secretary. It is noted the crux of the case is the missing fund when the so-and-so and the accused person is alleged to have been involved in misappropriation of the said missing fund. As such, re-examination of PW2 by the accused person is a valid reason to enable the accused person to shed more light to the case and also to prove his innocence, and in a word, it will help the court to arrive at a just decision and to avoid injustice and miscarriage of justice. This is the finding of the court, your lordship. What are the grounds, your lordship, filed by the accused, your lordship? Lordship will kindly come to page 22. That is the application, your lordship. What are the grounds?
Yes.
Lordship kindly come to para 2. That on going through the deposition of the PW deposed before the Supreme Court, in this, it has come to light that some pertinent question of facts that are vital for the interest of justice has not been placed by the previous defense counsel on so and so that who was then secretary. Lordship, in my humble and respectful submission, your lordship, this ground cannot be a valid ground for recalling of a witness who had already been examined for the purpose of recross examination. Your lordship, because the accused person, he was represented by the defense counsel, a mere fact that the earlier counsel had not put some facts, your lordship, before a witness, this cannot be a ground, your lordship. Mere change of a counsel, your lordship, is not a valid ground, your lordship, for the purpose of section 311 of this Code of Criminal Procedure.
You want to say omission to put any question cannot be a ground?
Yes, because the respondent accused here in lordship, he was represented by a defense counsel of his choice, your lordship. Just because an earlier defense counsel could not cross-examine properly the witness, your lordship, that cannot be a ground, your lordship. And to that, your lordship, I would like to reiterate by a decision of the Honorable Supreme Court, your lordship.
Yes. What is the decision?
Lordship, this is
Is it the 2016 to SCC?
2016, Your Lordship, yes, 402.
Yes, it's there. It's there.
It is there, Your Lordship. Lordship, kindly come to paragraph 13 first. This is the judgment referred, Your Lordship, in the earlier case, and the finding, Your Lordship, will kindly come to para 15. Para 15.
Yes.
The above observation cannot be read as laying down any inflexible rule to routinely permit a recall on the ground that cross-examination was not proper for reason attributable to a counsel. While advancement of justice remained the prime object of law, it cannot be understood that recall can be allowed for the asking or reason related to mere conveniences. It has normally to be presumed that the counsel conducting the case is competent, and particularly when a counsel is appointed by a choice of a litigant. Taken to its logical end, the principle that a retrial must follow on every change of counsel can have serious consequences on conduct of the trial and the criminal justice system. The witness cannot be expected to face the hardship of appearing in court repeatedly, particularly in sensitive cases such as present one, Your Lordship. Lordship, the principle, Your Lordship, is very clear, Your Lordship.
Yes.
That just a mere fact that the counsel has been changed and something had not been put by the earlier
Yeah,
counsel.
is it a case that counsel has been changed?
Lordship, yes. Lordship, kindly come again to kindly come to page 22, paragraph 2. Come again. Page 22, Your Lordship, paragraph
Yes.
paragraph 2, and that is Annexure 3. That on going through the deposition of the PW deposed before this honorable court in it has come to light that some pertinent question of facts on fact that are vital for the interest of the has not been placed by the previous defense counsel. This is a change of counsel, Your Lordship. This is not permissible in law, Your Lordship, in my humble and respectful submission.
Yes. Anything else?
Then, Lordship. Lordship, there is also one decision from the High Court of Delhi, Your Lordship.
Why this Supreme Court decision is not enough for you?
Lordship, no, Lordship, just to show that this is a reiteration of what the Honorable Supreme Court has.
That is not.
Lordship,
Then if it is the same reiteration, the same proposition.
Lordship, that is the same proposition, Your Lordship.
Any other point?
That is my only.
Yes, Mr. Jiva.
Wait, please, Your Lordship. Lordship, what my learned senior have pointed out that by reading my application, which I filed for the learned trial court, praying for the re-examination of PW2,
Yes.
is on the ground of change of counsel. That is not the ground, actually, Your Lordship. But if that be so, so Your Lordship, as per the Honorable Supreme Court in one of its judgment, which I have supplied, this is 2013 14 SCC 461. Just on this point, which my learned senior is banging upon, Your Lordship, that because of the change of counsel, it is not permissible in law for recalling the witness. Here, Your Lordship, para 15.6.
Yes.
Para 15.6. In so and so, the scope of section 311 CRPC has been highlighted by making reference to an earlier decision of this court, and also with particular reference to the case which was dealt with in that decision in para 20 and 23, which are as under. Grant of fairest opportunity to the accused to prove his innocence is the object of every fair trial. Observe this court in Hoffman Andreas versus Inspector of Custom. The following passage is in this regard opposite. In such circumstances, if the new counsel thought to have the material witnesses further examined, the court could adopt latitude and liberal view in the interest of justice, particularly when the court has unbridled powers in the matter as enshrined in section 311 of the code. After all, the trial is basically for the prisoners, and court should afford the opportunity to them in the fairest manner possible. So, Your Lordship, even if it is a case where I've gone through the trial court by saying no because of change of counsel,
Both are
on
by,
that ground, if I go, Your Lordship, even that is a case.
These both decisions are by two judges.
Yes, Your Lordship.
The decision
And in my humble submission, Your Lordship, even when I went before the trial court, that was not my ground. The ground was that he was certain right at the end of the examination of all the witnesses, Your Lordship. Even after perusing all the records of the depositions of all the witnesses, we found that there are some vital elements, some which were not brought before the that particular witness. Therefore, I've made the application. And if Your Lordship can come to the impugn order, that has also been recorded by the learned trial judge while disposing of my application under 311, Lordship. Lordship can come to page 25 of the impugn order. Page 25 of the impugn order. This will be the last paragraph of that page, Your Lordship.
Yes.
Where at the hearing the submission of the defense counsel, Your Lordship, the trial court have recorded. Learned 25. The last paragraph. This is the argument advanced before the learned trial court.
Yes.
Learned defense, on the other hand, submits that bare reading of section 311 CRPC suggests that the discretion lies with the court for recalling the witness for just decision of the case, and asserts that the accused person has come with an application to recall the witness to assist the court to come to a just decision, as PW2 holds a prominent position in the village and his re-examination is required to extract certain facts to enable this court to reach to a just decision, also contending that on perusal of evidence of PW1 and other witnesses, including the IO, none of the said witnesses deposed against the accused person, where the main issue is missing of funds, and contending further, learned counsel assert that PW2, being the secretary, was not thoroughly examined, and submits that if PW2 is recalled, if it's not recalled, there will be grave miscarriage of justice. Further, Your Lordship, if Your Lordship comes to the last paragraph of page 26, this is the reasoning given by the court. Having gone through the judgment, supra, this is the judgment which my learned seniors have also referred before the trial court, the 2016 judgment. The 2016 judgment, which my learned... Yes. So having gone through the judgment, supra, it is observed that an underlying principle of this judgment is that no witness should be candidly summoned for re-examination at the behest of the accused unless there is a strong and valid ground. However, it also talks about the discretion of the court to exercise its power to recall a witness for re-examination if it has to prevent injustice, and that it is not possible to lay down precise situation when such power can be exercised. The court, being mindful about the judgment and the facts and circumstances of the case, is of the opinion that application under 311 CRPC requires consideration for the very valid reason that PW2 was the village secretary as well as the secretary of the VWSC when the alleged missing funds took place, and he admitted that the funds can be withdrawn only by the accused and him, who were then the chairman and secretary of the VWSC respectively. It is noted that the crux of the case is the missing fund from the VWSC, and the accused person is alleged to have been involved in misappropriation of the said missing fund. As such, re-examination of PW2 by the accused person is a valid reason to examine the accused person to shed more light to the case and also to prove his innocence. In other words, it will help the court to arrive at a just decision and to avoid injustice and miscarriage of justice. So, Your Lordship, this is not a case where the learned trial court have not applied its mind, where upon my presentation of the application, which the learned trial court have just in a casual manner dispose of the application by allowing my application. The learned trial court have exercised its mind, hearing both the defense and the prosecution, and also were referring the judgment, which my learned senior have also pointed out before this honorable court, the 2016 judgment. And after hearing and perusing the judgment, it have come with this conclusion, Lordship. This is not a case where there is no reasoning. So, being mindful, Your Lordship, of Section 311. 311 have two ingredients in it. One is the discretionary part and one is the mandatory part. The discretionary part is that the court, if Your Lordship allow me to just read the 311 for Your Lordship's attention. 311, power to summon material witness or examined person present. Any court may. So the word may is, it gives the power of discretion. May at any stage of any trial or other proceeding under this court summon any person as a witness to examine any person in attendance, do not summon as a witness or recall and re-examine any person already examined. And the court shall, so this is the mandatory part, the court shall summon and examine or recall and re-examine any such witness if his evidence appears to it to be essential for the just decision of the case. So, Your Lordship, the court, the learned trial court, have exercised their discretion and have also exercised the mandatory part of 311, that is to give a reasoning as to why this application has to be allowed. And the reasoning given, Your Lordship, which I've just read, is very clear, because the PW2 is a person who is holding a post in that particular committee from which the missing fund is missing, and certain vital elements, facts were not brought to the court, and while also reading the judgment of referring to judgment on the 2016 judgment, have applied its mind and for the just decision have allowed the application. So, Your Lordship, in my humble submission, the trial court have not made any error by allowing the application. And further, Your Lordship, this 2016, Your Lordship, which my learned senior have pointed out at para 15. Para 15 of the 2016 judgment, Your Lordship, this has to be read in the context. Because why? Even here, the learned Supreme Court have brought out this observation on the context of the case. This matter was with regard to recalling of 13 witnesses in a 376 trial. In a 376 trial, the defense counsel have prayed for recalling of 13 witnesses.
So,
so the language used here also, Your Lordship, the witness cannot be expected to face the hardship of appearing in court repeatedly, particularly in sensitive cases such as the present one. This is the language used. So it has to be read in the context of what is there before the Supreme Court.
Context which was there before the apex court.
It's not the same.
It's not. It's totally
It's not at all the same. Not even close. I'm calling for a recalling of only one particular witness, Your Lordship, and for a case which is not of that magnitude, Your Lordship. The misappropriation allegation is only 2 lakhs, Your Lordship, and from the on 4th of December, Your Lordship, 4th December 2023, actually, Your Lordship have heard this matter at some length and have it has not passed a formal order, but have directed the defense to produce the position of the witness, PW2. So this is here with me, Your Lordship. Your Lordship have instructed not to file it, but just for Your Lordship's satisfaction, if I can, Your Lordship can read. Because here, Your Lordship,
this is the person who would be.
This is the person whom I've prayed for.
Is it very vital? I don't think
it's not vital, but Your Lordship have on the 4th of December when Your Lordship.
This is handwritten, isn't it?
No, type copy is also there. Just for Your Lordship's satisfaction. As to why? Because Your Lordship, if Your Lordship can come to page 5. Page 5, Lordship. And this will be question number 4. Post on the witness, Your Lordship. Page 5, question number 4.
Page 5.
Page 5.
Page 5. Okay, page 5, yes.
Page 5, question number 4, Your Lordship. Here, from which bank did you withdraw the money? Meghalaya, and the answer is from the witness, Your Lordship. Meghalaya Rural Bank, Makodok branch, for the first scheme for toilet that was implemented. We got a total of about rupees 2 lakh plus. Your Lordship can come now next to the.
That is what for you are referring it?
Question number, to show that there are discrepancy, because why, Your Lordship, the allegation in this matter was an amount of 2,87,000 so and so. And here, Your Lordship, he said that the amount that was missing, the total amount was of 2,60,000, but the misappropriated
Question 20 is it called Seniority?
Yes, and
that is
26
okay.
and 26.
So,
Your
what's
Lordship,
your advantage?
there are things, Your Lordship, because he, as per.
See, there is no question of confusion. If any witness make to define a statement with regard to the existence of one.
Yes, Your Lordship.
The law is well settled. The version which favors the accused, that will be accepted.
That will prevail. No, that is totally understood, Your Lordship. But for the defense case, Your
if you
Lordship.
say that is for precisely for this purpose,
No,
it
not
cannot be.
precisely for this. There are other factors also, Your Lordship, as to why. But coming back to this present case, Your Lordship, challenging the legality of the order of the impugned order, Your Lordship, I feel, in my humble and respectful submission, 311, it provides the discretion and it provides the mandatory part, which the learned trial court have exercised
Mandatory
judiciously.
part, if you say this is a mandatory part,
Mandatory to see with it for the ends of justice, Your Lordship.
now that is what is the problem. You see, what is for ends of justice or not, the court will have to exercise discretion to find it out.
Yes.
So then what becomes mandatory? In the similar sets and facts, if the court had rejected, then?
So the mandatory part here, Your Lordship, is the reasoning. How you are exercising the discretion. Whether the discretion that you have exercised in the first part of 311, whether it is going to achieve the mandatory part, which is for the just decision, and which the Honorable learned trial court, Your Lordship, have provided a justifiable
Been
reason.
able to make out anything from your submission, you see.
May I reply, Your Lordship? Lordship, so far the decision cited, Your Lordship.
You have finished, Mr. Jero has finished.
Yeah, he finished.
Your Lordship.
So far the decision 2013 judgment, Your Lordship, that has been referred by the Honorable Supreme Court in 2016. Lordship, kindly come to para 13 of the judgment. Of the judgment, 2016 judgment.
Para 13.
Lordship, yes. After referring to the earlier decision on the point, the court call out the following principle to be borne in mind. Rajaram case. Rajaram case, this is
2013.
This is the one relied by the defense counsel, Your Lordship.
Yeah, that is okay. But then
Lordship,
it
yes.
might have been.
So, Your Lordship, so the Honorable Supreme Court, after analyzing the principle, Your Lordship, has come to a conclusion at para 15, Your Lordship.
No, but then there's here this in this decision that is not distinguished, isn't it? Or it did not be discrete.
Yes, Your Lord, but the principle, the Honorable Supreme Court, after analyzing that Rajaram judgment, comes to a conclusion that a change of counsel cannot be a crown, Your Lordship, to recall a witness for the purpose of re-examination. The language is very clear, Your Lordship.
It's not the issue.
For a cross-examination, Your Lordship.
2016 judgment,
Lordship,
that was
can you see? The above observation cannot be read as laying down any inflexible rule to routinely permit a recall on the ground that cross-examination was not proper for recent counsel. While other advancement of justice remain the prime object law, it cannot be understood that recall can be allowed for the asking or reason related to mere convenience. It has normally to be presumed that the accused conducting a case is competent, particularly when the counsel is appointed by choice of a litigant. It is
but
not.
then if you see the earlier cross-examination by the legal aid counsel.
Yes, Lord.
The first cross-examination by the legal aid counsel.
Our Lordship, you should have raised that and then, Your Lordship, it is not for the accused. It's not the end of the road, Your Lordship. After 313, Your Lordship, he has the right to adduce evidence.
That is all right. But
he has the right. It is not that it is the end of the road. He has the right to
No,
to
but then
produce.
it's at the end of the road for the prosecution also, Your Lordship, because when I call for re-examination, they can also have the right to cross also. I mean, to object if I ask irrelevant question also, Your Lordship.
No, that
It's
is
not that I'll be asking the same question to harass the witness. They'll be there very much.
no, that is okay. That is understood. Why you are? I do not know why you are going in that line. That is not the issue.
No, saying that it'll be advantage only
See,
to.
the only thing is that the things which he can extract from this witness, he may not extract it from his defense witness. And same witness cannot be called as defense witness.
True, Your Lordship.
Anyway, just say hearing concluded. Order reserved.
Lordship.
These are the problem is that these two proposition of law. Is
But
by
Lordship, in
the bench
2016,
bench of equal strength.
2016, Your Lordship, that has been referred, Your Lordship. 2013, that has
Maybe
been
referred, but then it has not been disagreed with.
They referred only the principle which has been laid down in the 2013 judgment, Your Lordship, not the entire issue which has been discussed in that 2013 judgment.
2016 doesn't create a bar at all.
Doesn't create a bar.
It may says that yes, the circumstances, see, like that is what is to be. There is no absolute bar for
Apply, Your Lord.
Second call for supplementary list, item number 1.
Sorry, my room. The book. Yes, Mr. Singh.
My lord, it's a case, my lord, we are praying for